and welcome to this session of Leto Lectures, as we are now in the end stages of our look at the presidency 2020. By the time you see this, or as you are watching this, you may be in one of three circumstances. You may be watching this right before or maybe even on Election Day, November the 3rd. You may be watching it after Election Day, but before any definitive results have been released regarding who won the election. Or you may be watching this knowing who won the 2020 presidential election and thus who is going to be inaugurated president on January the 20th. Here is the map, of course, as it stands today. And just by way of a bit of preview, if on election night, a state like Florida, which tends to produce its results on election night, not counting 2020 and Bush v. Gore, or a state like North Carolina or Texas, which again produces their results very rapidly, have done so in a way that favors either President Trump or Joe Biden, we might know, even though Pennsylvania and Michigan, states that have only recently adopted mail-in voting as a direct response to the pandemic, to COVID-19, and the difficulty some people have waiting in lines and voting, if these early reporting states are consistently in favor of one candidate or another, even though there may be some time, and we're talking maybe a week and even more, before the results in Michigan and Pennsylvania are finalized, we may already know, notwithstanding those incoming results, who has reached the magic number of 270, and thus who is going to be the next president of the United States. Now, in the meantime, today we are going to talk about something, the federal judiciary, that we haven't really spoken much about in preceding lectures throughout the year. We've talked a lot about the legislative branch created in Article 1 of the Constitution. We further talked about the two parts of our legislative branch, or of our Congress, the House and the Senate, how those seats are won, how they're distributed, how they all come together to determine the number of electoral votes that each state has. Obviously, we've talked a lot about what was created in Article 2 of the Constitution, the office of President of the United States, the requirements to hold the presidency, the duties, obligations, responsibilities, powers of the president, and of course we've talked sort of to the point of a little bit of, ad nauseum, of the process, the system that we use, the electoral college system, to select our president. But what we haven't dwelled on a lot this year has been the branch created via Article 3 of the Constitution, the judicial branch, a co-equal branch of government, make no mistake about it, but one that is and was created to be a more anonymous, a more sequestered, and apolitical, unelected branch of our government. But recall, of course, that in the weeks and maybe the couple of months leading up to Election Day, leading up to November the 3rd, if you were really listening closely, you heard a lot about circuit courts of appeals making rulings regarding decisions of either governors or legislatures in states like Texas, South Carolina, North Carolina, Michigan, Pennsylvania, Florida, regarding a whole number of issues related to who can vote, how long the polls must stay open, how mailed-in ballots are properly certified, are witnesses needed in some circumstances for a mail-in vote to be legitimate, and can states, in light of COVID-19, in light of the great amount of autonomy that the Constitution gives to each state to set the rules regarding how it runs its elections, can states decide to count votes after election night? In some cases, votes that are received after election day, perhaps if they are postmarked on or before November the 3rd. And in some of the most important of these cases, we've seen the now 8-person Supreme Court issue rulings that will be, or have been, depending on when you're viewing this, very consequential into how the votes are determined state by state by state. So we've heard a lot from the federal courts, but they being, again, ones that do not typically permit television cameras, don't permit recordings. The Supreme Court in these types of emergency matters usually issues a very terse one-page ruling in one direction or another. We felt the effects of what courts have done, but not really dwelled on the personality of who actually occupies these very important judicial positions. Secondly, we've seen Republicans in the Senate, led by, of course, the Majority Leader, Mitch McConnell, work at breakneck speed following the untimely, the sad death of Justice Ruth Bader Ginsburg at the end of, in September. We've seen the Senate work very rapidly to render what the Constitution calls advice and consent to confirm President Trump's nominee to fill Justice Ginsburg's former seat, Amy Coney Barrett, a judge who sits on the 7th Circuit Court of Appeals. We saw a week's worth of hearings. The first day, of course, egomaniacal senators making largely self-serving opening statements, which took up almost an entire day. And then we had a couple of days of Judge Barrett do what recent Supreme Court nominees do when asked questions about important issues of the day, find some way to politely inform the panel that they are not going to render an opinion on issues of that type. So even though, as I stand here today, it hasn't happened yet, I suspect by the time you receive this, Justice Barrett will have joined the court to fill it out as its 9th member. And then, of course, be a 9th voice, perhaps, if there are any post-election issues that the Supreme Court might be called upon to resolve. We've heard on the campaign trail, certainly as President Trump in the Republican convention, and then in other venues as he sought to keep conservative Republicans, some of whom may not be wild about Donald Trump, the person, some of them who may not be wild about some of his policy deviations away from orthodox Reagan conservatism. We've heard Donald Trump trumpet the fact that in his 4 years as president, he has nominated and seen confirmed nearly 300 judges to various positions in the federal judiciary, each of whom, as we're going to see, is entitled to hold their positions for life. A very powerful argument regarding, really compared to recent times, a stupendous number of judicial seats that have been filled. And finally, perhaps in response to the rapid actions to confirm Judge Barrett, compared to 4 years ago, when in the last presidential election year, 2016, following Antonin Scalia's death on Valentine's Day, February 14th of 2016, after President Obama had nominated an individual to fill Judge Scalia's seat, a judge from the D.C. Circuit named Merrick Garland, Mitch McConnell, who then, like now, was the majority leader of the Senate, announced that the Senate would not take up the candidacy, the nomination of Judge Garland, because in his opinion, the voters should have a say in electing the president who would fill that seat. So that seat would remain empty for almost a year. And of course, Neil Gorsuch, who eventually filled Scalia's seat, was nominated not by President Obama, but by President Trump, a nomination that he put forward sometime after taking office, January 20th, 2017. So Democrats have been screaming double standard, from places farther and farther to the left of the political center of gravity in the United States, further to the left, for instance, of where the nominee Joe Biden was positioned. We've heard calls to pack the Supreme Court. And of course, we've heard from the right, from President Trump and just about everybody on his side of the political spectrum, calls that court packing would be the wrecking of yet another of our institutions so that Democrats could gain control of a now more politically motivated Supreme Court. So the term court packing, something we're going to talk about in a bit, has certainly been very much in the public and political discourse towards the latter stages of the campaign. Now, a lot of the reasons why there are sometimes uncertainties and misunderstandings about the judicial branch compared to Congress and the president was because at the Constitutional Convention in 1787, there were statements from delegates to that convention, particularly James Madison, about the judicial branch having to be an apolitical, unelected, insulated, neutral branch. I think the framers recognized that there was going to be a lot of give and take, a lot of infighting, a lot of shouting among and between those who occupied the two elected branches, Congress and the presidency. By predetermination, the judicial branch was sort of insulated, walled off, and made as securely as possible in the 1780s immune from the effects of more partisan rancor that again was going to be seen among the elected branches. So if we look at the Constitution, we see that Article 1 goes to some detail to delineate the requirements for being a member of both the House and Senate, the terms of office, and of course the broad powers given to Congress as a single entity. The Constitution in Article 2 again goes to pretty specific lengths to talk about all the powers that the president can exercise, and goes to great length to explain that electoral college process to select him. When we get to Article 3 and talk about the federal judiciary, we see that by far that is the most sparsely written, the most vaguely written, the most ambiguously written, and the shortest of any of the three parts of the Constitution creating any of our branches of government. So we're going to look today at Article 3, how it was written, and then look at how our federal judiciary has evolved over time, and how, in particular, the Supreme Court has led the way in putting the federal judiciary in positions to resolve many more types of disputes than perhaps the framers of the Constitution, the people who wrote it, envisioned when that document was created in the summer of 1787. Now, Article 3 begins by stating, "The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their office during good behavior and shall at stated times receive for their services a compensation, which shall not be diminished during their continuance in office." That is Section 1 of Article 3 in its entirety. And note, what it does is only create a single court, a Supreme Court, and leaves to Congress the responsibility of determining how many justices would sit on that Supreme Court, a number that throughout our history, as we're going to see in a bit, has changed through the legislative process. Bills sent to presidents who signed them into law, having the effect of, among other things, increasing or reducing the number of justices on our Supreme Court. In addition, Article 3 gives to Congress, by sending bills that presidents sign into law, the authority to create lower federal courts. And again, over time, through a series of quote-unquote judiciary acts, Congress has created two lower federal courts, the district courts, which are the trial courts of our federal system, and then an intermediary court and an appeals court, the circuit courts of appeals. Usually the end of the road for any traditional run-of-the-mill case brought to the federal system. These lower courts, very powerful, and like the Supreme Court, whose members are appointed for life, were again created by legislation and not created by the Constitution. Now, if you were one of the people writing the Constitution in 1787 and were worried about how these federal judges may be corruptible, may be subject to the blowing winds of public opinion, if they were elected, of course, like many state court judges are, they might have to be. The record shows, of course, that throughout the country, at the state level, we've seen all kinds of corruption among state court judges, county court judges, local magistrates. But in order to insulate the judges that would sit in this federal judiciary, by including the language holding their offices during good behavior, what the court essentially, what the framers essentially did, was to confer lifetime tenure on anyone occupying any of these seats in our federal judiciary. If you're a good little boy and a good little girl, you could hold your office for the entirety of your life. In addition, in order to create a modicum of economic security among judges at the federal level, maybe making them less tempted to offerings of bribes, the Constitution states that each of these federal judges should receive a salary, and that furthermore, that salary cannot be diminished during their times of service. So if Congress or the president don't like the way in which certain federal judges are ruling, they can't, through legislation, pass a law reducing the salaries of any of those occupying our federal judiciary. So the federal judiciary, again, walled off, protected, life tenure, gives them the ability to rule on the issues and only on the issues. And again, protection against the reduction of their salaries makes them more, financially secure, certainly during their tenure in office. A very unique component of our judiciary, and there are really no comparable independent created federal judiciaries in any other constitutional system around the world. Now, Section 2 of Article 3 tries to define where federal judicial power extends. What exactly is the jurisdiction of the federal judiciary? And Section 2 states, the judicial power extends to all cases in law and equity arising under the Constitution of the United States. Any cases brought raising a constitutional issue is one that will be heard by a federal court. To all cases affecting ambassadors and public ministers, to all cases of admiralty and maritime jurisdiction, the Constitution carves out the law of the sea and the various interesting applications and creations regarding maritime law and gives it to the federal judiciary, takes it away perhaps from the consideration of state courts. To cases in which the United States is a party, any person versus the United States heard in a federal court. To controversies arising between two or more states, one state suing another, heard by the Supreme Court. It has original jurisdiction, in fact, in a case where one state is suing another. To controversies between citizens of two different states, so-called diversity jurisdiction, diversity of citizenship, rather than have a case heard in one state or the other, which may be unfair to the non-resident participant in that case. Those cases will be heard at the federal level. And that, again, is Section 2, where the federal judicial power extends. Section 2 goes on to state that all criminal trials shall be heard by juries and held in the state where it shall have been committed. So the right to a jury trial in federal criminal cases is ingrained in the Constitution as written and later ratified. Section 3 goes on to define and talk about a word that we've heard thrown around a lot in the last 4 years, but maybe even more so in the last year during the campaign for president, and maybe even during the impeachment proceeding before, the word treason. Lots of people have been accused of committing treason. Treason is defined, however, in the Constitution as, well, treason against the United States shall consist only in levying war against it, or in adhering to their enemies by giving them aid and comfort, giving aid and comfort to the enemy of the United States. No person shall be convicted of treason unless on testimony of 2 witnesses to the same overt act. Treason, of course, was a highly charged word then. It's a highly charged word now. And in order to convict someone of it, 2 witnesses independently will have to testify that the defendant committed the same overt act, or upon confession by the accused in open court before a jury, I did it. The Constitution gives to Congress the authority to create criminal penalties, the proper criminal penalty for treason. Very serious ones, of course, can include the death penalty. That's it. That is the extent of what Article 3 does. Now, note that Article 3 does not explicitly give to the federal judiciary the power of judicial review, the power to, upon being asked, determine whether or not the actions of either the president or the Congress have somehow violated the Constitution or somehow unconstitutional actions. Maybe the substance or the nature of a bill coming from Congress and then signed into law by the president, or perhaps actions undertaken by the president, actions involving the carrying out of presidential duties and powers, or maybe whether or not an executive order, a sort of unilateral action by the president, complies and conforms with the law. Judicial review, something, of course, that takes up so much of the court's time today, was not explicitly asserted in the Constitution, and it wasn't until a landmark Supreme Court case in 1803, the case of Marbury versus Madison, that the Supreme Court ruled that the Constitution gave federal courts the authority to determine the constitutionality of the actions of either Congress or of the president. In the much more complicated world in which we live today, the much larger federal government, the vast collection of cabinet departments and federal agencies that exist within the executive branch, we recognize that judicial review is often the basis for federal courts determining whether or not rules promulgated by departments or agencies and enforced by them are constitutional or not are excessive or not. All again as part of this power of judicial review. So, following the ratification of the Constitution in 1789, Congress, in one of its very first actions, the Judiciary Act of 1789, determined that there were going to be two lower levels of courts: an appellate court, the circuit courts of appeal today as they're known, and a number of district courts, the trial courts of the federal system, both civil matters and criminal matters that were federal in nature would be tried at the district court level, and then most appeals would be taken at this upper court, one of the various circuit courts of appeals. The Judiciary Act of 1789 created the office of Attorney General in order to act as the chief law enforcement officer of the United States, a position, of course, like most presidential appointments, is appointed by the president and then confirmed by a vote of the United States Senate. And in the Judiciary Act of 1789, Congress set the number of justices on the Supreme Court, not at the current 9, but at 6, and authorized one of those 6 to hold the position of Chief Justice of the Supreme Court. I think in an editing error in the Constitution itself, when the Constitution explains the impeachment process, a federal office holder, most famously, of course, the president, is formally accused, impeached of high crimes or misdemeanors by the House of Representatives, but can only be removed if he is convicted on those charges by a 2/3 vote of the United States Senate. The Constitution says that the presiding officer, the judge of this impeachment trial, shall be the Chief Justice of the Supreme Court. Although in Article 3 of the Constitution, in creating the federal judiciary, there is not a mention of the Supreme Court having a Chief Justice. So in the Judiciary Act of 1789, Congress did just that. Now, as our country grew from 13 states to 50 states, as geographically the nation grew to the Mississippi River, then across to the mountains, and then all the way to California, and finally to Hawaii and Alaska. As the United States acquired extraterritorial possessions, places like Puerto Rico and Guam and the Virgin Islands and American Samoa, Congress has from time to time engaged in the writing of other judiciary acts, which were signed into law by presidents, that eventually would fill out our federal judiciary to settle on the number 9 for the number of Supreme Court justices, create 11 Circuit Court of Appeals, and one particular appellate court just for D.C., and among the 50 states and territories, create 94 federal district courts. More populous states have several districts where judges sit and federal cases are heard. Florida, for instance, has 3 district courts within our own borders, the very unimaginatively named Northern District, Middle District, and Southern District of Florida. Every state and territory falls within the jurisdiction of one of these 11 circuit courts of appeals. For instance, Florida, Alabama, and Georgia are the states that constitute the 11th Circuit Court of Appeal, so that any adverse ruling in a federal district court in any of those 3 states, Alabama, Georgia, and Florida, the appeal will be heard by the 11th Circuit Court of Appeal, which sits in Atlanta. And we'll have some more specific examples as we go on. So federal judiciary acts have been passed by Congress 1801, 1802, 1866, 1867, 1869, 1891, and 1925. And in each of those, the 2 elected branches, Congress by passing bills and presidents by signing them, have, of course, altered the nature and in some cases bits of the jurisdiction of our federal judiciary. All of this, of course, consistent with how the Constitution created this federal judiciary. So again, Marbury versus Madison, a very important Supreme Court case in 1803, because in an opinion written by Chief Justice John Marshall, who is the longest serving Chief Justice in our country's history, acting in that capacity for 34 years, the case of Marbury versus Madison, ironically, in the first case of judicial review, invalidated a part of the Judiciary Act of 1789, the very first time that Congress sought to fill out the federal judiciary. So that means that any American citizen can go to a federal court to assert that the action of a federal entity, be it Congress, be it the president, be it any cabinet department, or any law passed by actions of Congress and the president, were unconstitutional. And under the theory of judicial review, federal courts can make those decisions. In 1810, in a case called Fletcher versus Peck, Justice Marshall again wrote an opinion stating that federal courts have the authority to review and nullify, find unconstitutional state laws, again made at the state level by state legislatures, usually bills signed into law by state governors. So the reach of the federal courts and their powers under the Constitution following Fletcher versus Peck gave the federal courts the ability to review and possibly invalidate state laws. And over time, we saw the number of justices on the Supreme Court change from 6 to 7 to 9. During the Civil War, for a period of time, there were 10 justices on the Supreme Court. During the Civil War, of course, a number of southern states seceded from the Union, but federal Supreme Court justices who had come from those Confederate states remained loyal to the Union and continued to sit on the Supreme Court, making President Lincoln and the Congress at the time, which of course consisted only of Union states, a little concerned of the ultimate loyalty of these justices. The number was raised to 10 in order to ensure that there were enough votes to overtake any actions by these Southern judges. And then in 1869, in another judicial act, or Judiciary Act, the number was set at 9, and that is the number that has existed all the way until the present time. Now, following the conclusion of the Civil War, we know that Congress had some work to do in order to, among other things, change the status of individuals that prior to the Civil War were slaves, African slaves and their descendants, who after the war were now going to become fully empowered American citizens. And we know that in the 4 years following the end of the Civil War, the war ended in 1865, three amendments were sent by Congress to the states, the results being the 13th, 14th, and 15th Amendments. In December of 1865, 9 months or so following the end of the Civil War, states ratified the 13th Amendment, which permanently and forever banned slavery within the United States. However, and then later in 1869, states ratified the 15th Amendment, which gave to all former slaves the right to vote, saying that the right to vote shall not be abridged on the basis of race, color, or condition of previous servitude. But we know, of course, that in theory and in reality, that right to vote in many states was given only to former male slaves, because many states still had not extended to women of any color or stripe the right to vote. But the 15th Amendment, again, was a step forward in giving to former male slaves the right to vote. Now, the 14th Amendment was one that had to do a lot of things, and it would be ratified in 1868. For one, it had to deal with the effects of a Supreme Court decision that had been rendered by the court in 1857, the infamous Dred Scott decision. Supreme Court cases are such that when a court rules with finality in any matter, there of course is no recourse to a higher court. The Supreme Court is the highest there is. And unless a future court comes along and determines that a ruling on an issue that a previous version of the Supreme Court had made 10, 50, 100 years ago was wrong, and unless that subsequent court comes along and changes the court's position on an important issue. We know, of course, in 1893, the Supreme Court, in the case of Plessy versus Ferguson, ruled that regarding accommodations for people of different races, like trains, people of different races could be forced to travel in different train cars. They could be separated, provided the accommodations were equal. Separate but equal became the law of the land in schooling, in hotel accommodations, in so many different areas, until 60 years or so later, in 1954, the Supreme Court in Brown versus Board of Education ruled that separate but equal could never be constitutionally permissible in the United States, and all of a sudden the doctrine of separate but equal was eliminated. We know, of course, that 47 years ago, the United States Supreme Court issued its opinion in the case of Roe v. Wade regarding a woman having a constitutional right to an abortion. And we know, of course, now with Judge Barrett's probable confirmation, the Supreme Court would have a pretty distinct 6-3 conservative-leaning majority, which means that if a case were presented to the court, and if the court agreed to take it, it could re-examine the decision rendered in Roe and affirmed in others, and articulate a new rule regarding what heretofore has been this federally recognized constitutional right to abortion. It is entirely within the province of the court to do this. But assume that doesn't happen, and a rule rendered by the Supreme Court on a particular issue is final. The only way that that state of the law, as rendered by the Supreme Court, could be altered or overturned is by amending the Constitution to speak specifically to the issue and the state of that issue as left by the Supreme Court. So the Dred Scott case involved a slave by the name of Dred Scott who had been taken by his owner from a southern slave state to live for a time in a non-slave state. I believe the state was Illinois, and then brought back to the slave state from which they'd first come. Attorneys on behalf of Dred Scott went to the federal courts and asked the federal courts to rule that because Dred Scott had lived for a time in a free state, that somehow conferred freedom from the bondages of slavery to Dred Scott. So the case made its way up to the United States Supreme Court, who really ruled in a way that didn't address the ultimate issue. Was Dred Scott a free man because he had lived for a time in a free state? The court essentially in 1857 said that Dred Scott did not have the standing, that he could not go to a federal court to ask it to rule on a matter of federal constitutional importance, because in the Dred Scott decision, the Supreme Court ruled that African slaves and their descendants were not persons for the purpose of claiming citizenship rights under the Constitution. Dred Scott was, the court analogized, more of a chattel, a possession that was bought and owned and sold, and therefore as a chattel did not have standing to raise a federal issue. So 8 years after the Dred Scott decision, 1865, the Civil War is over. The nation is in the process of being reconstructed. But Dred Scott, that case still hung out there as good law. That was the nature of the status of former slaves. So the only way it could be overturned or changed was by a constitutional amendment. And that's exactly what Congress did when it produced the proposed 14th Amendment, when it was sent to the states, and ultimately in 1868, enough states voted to ratify it, and it became part of the Constitution. The first section of the 14th Amendment cures the Dred Scott issue by stating that anyone born in the United States is a citizen of the United States and of the state in which he resides. Congress, rightfully figuring that just about every former slave, the 13th Amendment had abolished slavery, but they weren't citizens either, former slaves, because of Dred Scott. Congress reckoned that probably just about every one of these former slave non-citizens were born somewhere in the United States. So by using that language, anyone born in the United States, they probably covered 99.9% of these former slaves. And through this birthright citizenship provision, waved a wand and conferred citizenship on all these former slaves. Now, Congress in 1867, 1868, was very much an activist Congress. It was led by a Republican Party referring to themselves as the Radical Republicans, who were very much eager to punish, I don't think that's too strong a word, those states that earlier had seceded from the Union, causing of course, American Civil War. So the 14th Amendment goes on to speak via the Constitution, not to Congress, not to the President, not to any federal entities, but to the states directly. For the very first time, the 14th Amendment states that no state shall deprive any of its citizens of life, liberty, or property without due process of law, and that every state shall provide equal protection of the law to all of its citizens. No citizen or group of citizens could be held out for more favorable or unfavorable treatment because the Constitution required equal protection of the law. Now, notwithstanding this, of course, we know that when Reconstruction ended, following a political deal to resolve the deadlocked presidential election of 1876, many southern states began creating and imposing slates of laws that we call collectively Jim Crow legislation that greatly reduced the rights of these now citizen former slaves and their descendants, in many cases violating vis-a-vis these individuals' constitutionally protected rights. And from 18 1880, to the 1920s, there were numerous attempts to cause federal courts to enforce violations of the federal Bill of Rights in the event states or local entities, state legislatures or local sheriffs or local mayors or local city councils violated fundamental constitutional rights. So to make a very complicated legal argument a little more understandable, the Supreme Court, for the very first time in 1925, in a case called Gitlow versus New York, determined that when the Due Process Clause stated that a state shall not deprive a citizen of life, liberty, or process a state shall not deprive a citizen of life, liberty, or property without due process of law, the court defined liberty rights to be all the important fundamental rights guaranteed under the federal Bill of Rights. So for the last nearly 100 years, in a series of landmark cases, the Supreme Court has identified certain rights guaranteed under the Bill of Rights, declared them to be quote-unquote fundamental constitutional rights, and thus through the Due Process Clause of the 14th Amendment has given federal courts the authority to find that actions taken by state and local entities against individuals or different groups violate the Constitution and are thus unconstitutional actions. So over time, we've seen freedom of speech, freedom of religion and from religion, freedom of the press, freedom of assembly. We've seen all the protections against illegal searches created by the Fourth Amendment. We've seen in the Fifth Amendment protections against self-incrimination and double jeopardy. We've seen the Sixth Amendment's right to counsel. We've seen the Eighth Amendment's prohibition against cruel and unusual punishment, over time found by the Supreme Court to be fundamental constitutional rights and thus enforceable against the actions of individual states, and in some cases, even smaller entities. Landmark cases involving freedom of religion or compelled prayer, as the term went, in public schools were found to be unconstitutional because, again, religious freedom was identified as a federal constitutional right. A whole slew of different state laws regarding the scope of searches and seizures were found to be unconstitutional because the Supreme Court, in a case called Mapp versus Ohio, found the rights created under the Fourth Amendment to be fundamental constitutional rights, so that individuals who believe that illegal searches were conducted against them by local police can go to a federal court to have that court determine whether or not it deviated from the protections of that law. Miranda versus Arizona. The requirement that police advise people in custody about to be questioned of their constitutional rights was an appeal from an Arizona case where local officials detained, deprived of sleep, maybe administered a little bit of what the police sometimes call pain therapy to a man named Ernesto Miranda, after which he confessed to a crime. When the Supreme Court heard the Miranda case, it articulated the rule regarding, again, the need to advise individuals of their constitutional rights prior to being questioned. The case of Gideon versus Wainwright, a Florida case, caused the Supreme Court to rule that the right to counsel articulated in the Sixth Amendment was a fundamental right, meaning that anyone charged with a crime that could result in their incarceration, state or local crimes included, had to be provided with an attorney. Prior to 1963, when Gideon versus Wainwright was decided, that was not the case. More recently, within the last dozen years, we've seen the Supreme Court act on the Second Amendment. The Second Amendment, for a very long time, was alluded to by lots of gun right activists and opponents in the United States. But the Second Amendment was one of the least acted upon by our federal judiciary. What exactly does the Second Amendment mean? A well-regulated militia, comma, being necessary to the security of a free state, comma, the right of the people to keep and bear arms, comma, shall not be infringed. The Second Amendment hung around for more than 200 years without being given any more of a specific definition until 2008 in a case called Heller versus District of Columbia, where by a 5-4 vote, the Supreme Court stated that the Second Amendment gives every American the right to keep and bear arms in their homes for self-defense, a very generous interpretation of the Second Amendment by this 5-justice majority. And then 4 years later, in a case called McDonald versus Cook County, I believe, the Supreme Court ruled that that right to keep and bear arms was a fundamental constitutional right. That means anyone in the United States can go to a federal court to assert that local laws restricting their rights to certain types of firearms are unconstitutional. A broad expansion of court power. Much of what the courts do today are considering actions of state and local courts that only through the Due Process Clause of the 14th Amendment have exposed all of these fundamental rights created in the Bill of Rights to scrutiny by federal courts against state and local actions, a very important component there. So, all federal court justices, all federal court judges are nominated when a vacancy in one of them occurs by the president and are confirmed by a vote of the United States Senate. The term the Constitution uses is advice and consent. Since 2017, the Gorsuch confirmation, and actions earlier when the Democrats controlled the Senate, the ability to filibuster any judicial nominee no longer exists. So all that is required to confirm any one of these federal judicial nominees is a simple majority vote. If all 100 senators are present, 51 have to vote, or in a 50-50 tie, the vice president breaks the tie to confirm any of these individuals. Again, there are 94 federal district courts, 3 of them in Florida, several in California and Texas and in larger states. But in most small to medium-sized states, there is one federal circuit court for the entirety of a state: Nebraska, North Dakota, Montana, Wyoming, etc. Filling positions in those 94 federal district courts are 678 federal district court judges, each district court typically having several judges assigned to hear cases in that matter. Every one of those 678 nominated by the president, confirmed by the Senate. Now, if you have an adverse ruling again in a federal district court, the Circuit Court of Appeals is the place where, in criminal cases, a convicted individual is entitled to an appeal, and where many civil verdicts at the district court level are considered. Every state is located in one of these 11 numbered federal circuits. For instance, the Second Circuit Court of Appeals includes the states of New York, Connecticut, and Vermont, and it sits in New York City. The Third Circuit Court of Appeal hears cases coming again from the district courts of New Jersey, Delaware, Philadelphia, and the Virgin Islands. And this Third Circuit Court of Appeal sits in Philadelphia, because there is a federal district court in the Virgin Islands. Imagine being the poor federal judge that has to hear cases there. The Ninth Circuit Court of Appeals, covering a huge swath of the western United States, hears appeals from most of the western states, including California. About 20% of the population of the United States live in one of the states where the Ninth Circuit Court of Appeals is the appellate court, and it sits in San Francisco. Because so much law and so many federal actions emanate from the District of Columbia, Washington, D.C., not a state yet, if some have their way, there are federal district courts that hear cases taking place exclusively in D.C., almost all of them dealing with some aspect of government, and D.C. has its own Circuit Court of Appeals, viewed by many as the second most powerful court, second only to the Supreme Court in the United States. In recent years, we've seen Justices Ginsburg, Clarence Thomas, John Roberts, Antonin Scalia, Brett Kavanaugh, all eventually, of course, Supreme Court justices. They were elevated after having occupied a seat in this one court, the D.C. Circuit Court of Appeals. 9 justices, of course, on the Supreme Court. There is currently a different kind of split on the Supreme Court, 4-4. 4 justices, Clarence Thomas, Sotomayor, Kavanaugh, and Leto, graduated from Yale Law School. Another 4, Gorsuch, Kagan, Breyer, and Chief Justice Roberts, graduated from Harvard Law School. Amy Coney Barrett a graduate of Notre Dame's law school will break what for a very long time has been this duopoly. Supreme Court justices coming only from two law schools, Harvard and Yale. Historically, the Supreme Court, deep into the 20th century, in fact, was a bastion of white, male, Protestant judges and jurisprudence. If Justice Barrett is already confirmed by the time you see this, she will be the 115th, 115, justice to sit on the United States Supreme Court. Among them have been 17 chief justices, which again have occupied this congressionally created position of Chief Justice of the United States Supreme Court. If Justice Barrett is confirmed, she will be the 14th Catholic justice to sit on the Supreme Court out of 115, and on this current court would be the 6th Catholic justice to sit on our nation's high court. Chief Justice Roberts, Clarence Thomas, Sam Alito, Sonia Sotomayor, Brett Kavanaugh, and Amy Coney Barrett would be the 6th. For whatever it's worth, Neil Gorsuch is an Episcopalian, which is almost Catholic, but he was raised a Catholic and attended the same Jesuit Catholic high school that Judge Kavanaugh did. So maybe we count him as half a Catholic, 6.5 Catholics on the Supreme Court, 7 for all intents and purposes. Justice Kagan and Justice Breyer both being Jewish. Prior to Gorsuch reaching the court, in one of the great ironies, something that the framers of the Constitution would have looked at and said, how in the world did that happen? There were no Protestant justices on the court. For a very long time, 6 Catholics, 3 Jews. Gorsuch again, the Episcopalian joining the court. In the court's history, there have been only 8 Jewish justices on the court. The first, very famously, of course, confirmed in 1917, Louis Brandeis, a great counselor to President Woodrow Wilson. You know, Wilson, this very difficult to comprehend American president. In many cases, of course, someone who was so farsighted, a lion of progressive policies, but he came from Virginia and was definitely a segregationist and a racist. Nonetheless, saw and helped push through the confirmation of Justice Brandeis as the first Jewish justice in the court in 1917. In the early 30s, he was joined by a renowned New York State Judge, Benjamin Nathan Cardozo. Later, Felix Frankfurter would join the court. Arthur Goldberg in the 1960s, Abe Fortas as well, and then finally, Justices Ginsburg, Breyer, and Kagan. Until recently, of course, those 3 had been on the court since 2012, the last 3 Jewish justices on the court. There have been 2 African American justices to sit on the court out of that 115. Thurgood Marshall, of course, appointed by President Johnson, the first African American justice to sit on the court. He was followed 24 years later in 1991 by Clarence Thomas, who was nominated by the elder President George Bush after Thurgood Marshall's retirement to fill what informally came to be known as the black seat on the court. But it's interesting how judicial philosophies can be different. And just because people are of the same religion or the same race or the same age doesn't necessarily mean they are going to see legal matters the same way. The New York Times a few years ago did a detailed analysis trying to place every justice who sat on the court from 1950 to the present time on a spectrum, considering how they ruled in every case that they considered as a justice on the court, and eventually came up with a spectrum running from the most liberal justice to sit on the court since 1950 to, based on their rulings, the most conservative justice to have sat on the court since 1950. And you've probably figured this out. Thurgood Marshall was considered to have been the most liberal justice on the court for this more than 60-year period. And yes, his replacement, Clarence Thomas, adjudged to be the most conservative of all the justices who sat on the court during this period of time. There has been one clearly Latino, Hispanic judge to sit on the court, and that is Judge Sonia Sotomayor, who was nominated by President Obama. Some have made the case that because Justice Cardozo was a Sephardic Jew whose ancestors had come from Spain, that perhaps Cardozo deserved recognition for perhaps being also the first Hispanic judge to sit on the court as well. So we've got this court now that President Trump has made 3 nominations to, probably all 3 confirmed, and as a result, this 6-3 conservative to liberal tilt on the Supreme Court probably, certainly over time, when we look back at the most important accomplishment of President Trump's first term in office, maybe his only term in office, who knows, over time, the fact that he has filled nearly 300 seats in our federal judiciary and 3 on the United States Supreme Court alone will probably be considered the most consequential act of his presidency. Now, one last comment. Congress has the right, through legislation, to create new courts and, as we mentioned before, change the number of justices on the court. In 1933, after Franklin Roosevelt had been inaugurated president and began the most fundamental change in the relationship between the federal government and the states, where in order to deliver relief, recovery, and then reform to institutions during the Great Depression, FDR created federal agencies, a friendly Congress created all types of federal legislation, and we would see the federal government acquire many more powers vis-a-vis the states, affecting American citizens throughout our country. FDR's election brought huge majorities to Democrats in both the Senate and the House, but the Supreme Court that was sitting when FDR came into office was, of course, a court that had been appointed by FDR's predecessors most of them in the 1920s, most of them appointed by Republicans, Warren Harding, Calvin Coolidge, and Herbert Hoover. These justices initially ruled that many of the actions that Congress had sent to President Roosevelt, that he signed into law, many in FDR's first 100 days, in the eyes of this more conservative court, were not constitutional, were violations of separation of power, of the powers of Congress, or the powers of the president. President Roosevelt began referring to the Supreme Court as a court consisting of 9 old men, of a court living in the horse and buggy era. After the court invalidated 2 landmark pieces of legislation, the Agricultural Adjustment Act and the National Recovery Act, attempts by Congress and the president to really fix prices or create a threshold for prices of crops and of manufactured goods, the Supreme Court found both of these acts to be unconstitutional, meaning that other actions that Congress had taken at the president's behest, the creation of the Securities and Exchange Commission, Social Security, the National Labor Relations Act, the right to collective bargaining, might be endangered as well. So after President Roosevelt won his second term in 1936, and after Congress ended up consisting in the Congress that met in 1937, the 75th Congress, Democrats had a majority in the House, 333 to 89 Republican seats. In the Senate, 76 Democratic senators, 16 Republicans. FDR sent to that Senate the Judicial Procedures Reform Act of 1937 in February of that year. In March of 1937, FDR dedicated his 9th fireside chat to trying to sell the American people on the content of the Judicial Procedures Reform Bill, which said, or FDR said, that because there were so many older justices, men in their 70s, the Supreme Court was not hearing enough cases, and in the preceding terms had refused to hear 87% of the cases that it was asked to hear. The fact of the matter was, back then, the Supreme Court heard many more cases than it does these days on an average cycle. But the president's argument was, these old guys, these 9 old men, can't get the work done. So the bill that the president sent to Congress would permit the president to appoint an additional justice for every justice on the court who was over the age of 70 years, 6 months old, to sort of help the old geezers out in handling their caseload. If it became law, it would have permitted FDR to appoint 6 additional justices to the Supreme Court. They would have been confirmed by the Senate, and bam, this number 9 would have been 15, except FDR underestimated at the time the impulses by both the leaders of the House, all Democrats, but in particular the majority leadership in the Senate, Democrats as well, to protect the federal judiciary and particularly the Supreme Court from this crude attempt to instantly create a favorable court to the New Deal policies by creating enough new justices who would be nominated by the New Deal president. What happened, of course, was the justices on the Supreme Court, watching what was happening between the president and Congress, suddenly were enlightened, if that's the right word. One justice in particular, Owen Roberts, voted with the more liberal members of the court to uphold the constitutionality of Social Security, to uphold the constitutionality of the National Labor Relations Act. The momentum to pack the court, the urgency to pack the court, was very rapidly reduced, not as necessary. Justice Roberts, Owen Roberts, change of philosophy has been referred to as the switch in time that saved 9. And then soon, later in 1937, by 1938, Mother Nature began to take its effect. Older justices began to retire, and soon FDR would be able to appoint justices like William Douglas and Hugo Black and Felix Frankfurter, and all of a sudden he would have a very favorable pro-FDR, pro-New Deal, more modern-looking Supreme Court. But that attempt to pack the court is what, of course, has been alluded to during the campaign. Again, traditionalists would look at it and wring their hands and the gnashing of teeth. But if by this time Democrats have a majority in the Senate, or at least a 50-50 tie, if Joe Biden will be the new president, they will have in their control, through a few parliamentary measures, the ability to come up with a rationale to change this number. It would not be unconstitutional. It would be politically unpopular. It would be very polarizing, I guess, just like everything else. We know that from the farther leftward flanks of the Democratic Party, up until the election, there have been calls to just say the court is too small, we've got to increase its size. In 1869, there were only 40 million people in the United States. Now there's 340 million. So we might see that this question of 9, and is that a number cast in stone, which it constitutionally is not, will be something that we'll continue to talk about as we make our way through 2021. Now, about a week after you see this lecture, I will have created and sent to your community, as fast as the mails can take them, a wrap-up of hopefully what will be the final results of the presidential race. We'll have the exit polls, we'll do our post-mortem analysis, we'll consider who won Florida and Georgia and North Carolina and Pennsylvania, Ohio, Michigan, Wisconsin, Arizona. Was Texas really in play, or was that just sort of a tease or a bluff? And we'll have the exit polling data to tell us why the person who won the election won, which will probably have also a lot of insight of why the loser did not. The next lecture will be our post-mortem analysis of the race for the White House in 2020. So as always, thank you so much for joining us, and we'll talk to you again very soon. Take care.